Good morning, everybody. Good morning. Good morning. I'm your host, the Supreme Litigant, and I'd like to welcome everybody back to Smart Loke TV. Before I begin, y'all already know the routine. If you haven't already, please hit that like and that subscription button. Turn that notification bell on before we begin this video. I'll give y'all a second to do that. All right, so I'm going to jump right into this. Where is that case at? Right there. Okay. This is a case where I want to talk about. Posted some excerpts from the case yesterday on the community section of my YouTube channel. So I think this is a pretty good case because I know some of y'all may have heard me say that, and I quote, "I don't care if there's 1,000 judges' signatures on an arrest warrant. If the warrant is not supported by probable cause, then it is not a warrant, even if a judge signs it." So, with that being said, I want to stress to y'all um, the importance of understanding what probable cause is and how to determine if a police officer who is trying to arrest you has in fact probable cause to arrest you. You need to understand that. Probable cause is a mixed question of law and fact, meaning the facts of the case um, and the relevant case law will determine if you have been lawfully arrested. So, for example, police officer arrests you for disorderly conduct on such and such facts. He does it under a particular statute. So what the judge will do is the judge will read that statute, interpret that statute, apply the facts of your case that the police officer is using to base probable cause on, and the relevant case law that has interpreted the statute that the officer is alleging that you violated. And the judge, the so-called judge, will then determine if you have been lawfully arrested as a matter of law. That's what's going to happen. That's how they do it. That's how you do it. That's how you determine if you have a valid cause of action to sue the police. It's the same shit, y'all. The same exact shit. These people are not smarter than you. They just read. That's it. So I'm not going to read this whole case. I'm just going to read parts of it to give you an idea. And then I'm going to read to you what the court held in regards to what I'm about to read. So where are we? I'll start right here. According to the complaint, which the court must presume true at this stage, this case arises from October 10, 2014, from the October 10, 2014 search of plaintiff's District of Columbia home pursuant to a warrant obtained by MPD Officer Jerry Afari. The officers, however, were looking in the wrong place. It turns out that Steve Williams, another man who was arrested on the street for possession with the intent to distribute heroin, had given Davis's address as his own. MPD officers then checked this purported address in their justice database, and with the pretrial services agency, both of which confirmed that the address Williams had provided was indeed where he lived. In actuality, plaintiff maintains Williams had no significant connection to Mr. Davis's residence, and though the two men used to be acquaintances, Williams never spent even one night at Davis's home. Interesting. In his warrant application, Afari averred that based on his training and experience, persons who, notice they're saying persons who deal in illegal controlled substances, notice they're saying illegal and not unlawful, deal in illegal controlled substances, maintain evidence of illegal activity, usually secreted in their residences or the residences of friends and family members, or in places of drug distribution activity, such as a stash house or safe house. On the basis of this knowledge, he requested permission to search what he thought was Williams' home for, among other things, that's what inter alia means. It means among other things in Latin, if I'm not mistaken. Narcotics, illegal drugs, packaging, and proceeds of drug sales. Let's see. Warrant application. District Court. I'm sorry, y'all. District of Columbia Superior Court Judge John Bailey approved the warrant. All right, so I'm gonna pause right there, and I'm gonna go to the second part of the video. Okay, now I'm gonna read y'all the plaintiff's argument. In plaintiff's account, Davis was at work at Fresh Cut Barbershop when a phalanx of heavily armed officers kicked his door off its hinges, stormed his apartment, and ransacked his entire place. Although they found nothing illegal in Davis's home, MPD officers ruined a week's worth of meat along with the other food that Mr. Davis stored in his apartment, shredded his lazy bar armchair and his mattress, and seized Davis's computer. The officers subsequently returned the computer on another occasion. After the search, the officers contacted the property manager at Davis's address, who provided videotape evidence confirming that Mr. Williams had no connection to the residence. At the heart of plaintiff's complaint is his allegations that the sweeping generalization about a large and diverse set of individuals that Afrori presented in his warrant application as gleaned from his training and experience provided woefully insufficient grounds for approval of such a warrant. Davis alleges that, in the vast majority of cases in which MPD officers execute search warrants after a traffic or street stop based only on their training and experience, and not actual evidence connecting the home to criminal activity, the warrant returns submitted by the officers themselves to prove the MPD officers do not find the items that they seek. More specifically, he submits that in the year preceding the search at issue here, MPD officers failed to find any drugs, let alone the drugs they were looking for, in almost 66% of the cases in which they executed training and experienced search warrants. I'm sorry, y'all. So he must have got this information from somewhere. If the plaintiff is alleging these as factual allegations in his complaints to support his reasonable conclusions, he must have gotten this information from somewhere. So this is probably in an amended complaint, or he got this information before he started drafting his lawsuit. Anyway, let's see. And if small amounts of marijuana are excluded, MPD officers failed to find illegal drugs that they were purportedly searching for in nearly 87% of the cases involving training and experience warrants. In Davis's view, these dismal statistics, I'm guessing that's what it is. These small statistics reveal that Afrori and his new fellow officers knew through their training and experience that sophisticated drug dealers do not provide law enforcement with the location and address where they keep their stashes and evidence for their crimes. He further, when y'all see stuff, let me show you. When y'all see stuff like that, the so-called judge is quoting from the complaint. That's what they're doing. So this is at paragraph 44 in that complaint. He further believes that Afrori knowingly and recklessly omitted from his application the poor success rate of such warrants, and thereby deliberately misled the issuing judge. That's a good, reasonable conclusion. I agree with that. That's a reasonable conclusion. Plaintiff brings 42 Section 1983 suit against Afrori and 25. That is crazy, y'all. 25 unnamed MPD officers who executed the search all in their individual capacities and against the district as recompense for their Fourth Amendment violations. As recompense for their Fourth Amendment violations, Davis seeks general damages from all defendants as well as punitive damages from the individual officers. Yeah, 13 defendants now move to dismiss all of plaintiff's claims. So now they move to dismiss the case now. These are the defendants. I'm assuming that they are moving to dismiss this case on qualified immunity grounds, or they're going to argue that they got this search warrant from the judge. The judge signed it, and that a reasonable officer. It's gonna be something like that. They're gonna argue something about a reasonable officer, something like that. All right. After I read this particular part, I'm gonna go and read the plaintiff's argument, and then I'm gonna scroll down and read if they were denied or granted qualified immunity. I'm gonna pause the video and I'll be right back, y'all. Give me a second. All right, y'all. Sorry about that. Federal Rule of Civil Procedure 12b-6 provides for the dismissal of an action where a complaint fails to state a claim upon which relief can be granted. In evaluating defendant's motion to dismiss, the court must treat the complaint's factual allegations as true and must grant plaintiff the benefit of all inferences that can be derived from the facts alleged. So what this basically means is, we're going to substitute all inferences, and we're going to say, and treat the complaint's factual allegations as true and must grant plaintiff the benefit of all reasonable conclusions that can be derived from the facts alleged, if that makes sense, because that's essentially what it is. And an inference is a conclusion that can be derived from from a set of facts. The notice pleading rules are not meant to impose a great burden on a plaintiff, and she must thus be given every favorable inference that may be drawn from all the allegations of fact. Although detailed factual allegations are not necessary to withstand a Rule 12b-6 motion, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. Plaintiff must put forth factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. The court need not accept as true a legal conclusion couched as a factual allegation. This is why I keep telling y'all, you can't make conclusions in your complaint. You can't make conclusions in your complaint unless you have facts to support on how you came to that reasonable conclusion. You can do it that way. Nor an inference unsupported by the facts set forth in the complaint. For a plaintiff to survive a Rule 12b-6 motion, even if recovery is very remote and unlikely, moreover, the facts alleged in the complaint must be enough to raise a right to relief above the speculative level. So let's see. That's the legal standard, by the way, for a Rule 12b-6 motion that I just read. Remember when I told y'all that these motions have standards? That's the legal standard. In evaluating the sufficiency of plaintiff's complaint under Rule 12b-6, the court may consider the facts alleged in the complaint, any documents either attached to or incorporated in the complaint, and matters of which the court may take judicial notice. The court may thus consider those materials on a motion to dismiss without treating the motion as one for summary judgment under Rule 56. I'm guessing that's C, if I'm not mistaken. So, just to let y'all know, if you're at the pleading stage and you filed your complaint, they've been served the complaint, and now they're coming back and they're filing a motion to dismiss the complaint, and they're attaching all types of evidence to use in support of their motion for complaint, but they did it under Rule 12b-6. When they do that, the court can, if it wants to, treat that Rule 12b-6 motion as a motion for summary judgment if it's going to consider matters outside of the pleadings. So let's see. I'm not going to read that. I want y'all to read that. I'm going to get down to the point of the case. All right, y'all, I'm back. Sorry about that. Okay, I was just skimming through this case. I did a cursory review of the case. I think I'm going to read not all of this case, but most of it. I'm going to read everything that I think is important. However, I would advise y'all to read this case too. Now, the reason why I'm going to read most of it is because this case touches on a lot of important stuff that I think everybody needs to know in regards to the Fourth Amendment's reasonableness standard. So I'm going to read most of it. So this will probably be about an hour or a little over an hour video. Davis's complaint includes 4 counts. They allege that 1, a Ferrari's warrant application was so lacking in probable cause that no reasonable officer could have relied upon it in good faith, meaning that the officer's execution of the warrant violated the Fourth Amendment. A Ferrari made knowingly and recklessly false statements and omitted material facts from his warrant application in violation of the Fourth Amendment. 3, the deficiencies in the application were part of a pattern or practice of similar behavior by MPD. So he's trying to get the city in on this. He's trying to bring a cause of action against the city under a Monell claim. That's why he made that allegation. Also, this is what a conclusion looks like in the complaint. When you say the officer unlawfully or illegally arrested me, something like that, but you don't have facts to support how the arrest was unlawful or illegal, or so to speak, like that. Police officers do this all the time. They'll say you committed the crime of disorderly conduct by making loud, unreasonable noise, and that'll be it. What they'll do is they'll copy and paste the statute, and they'll probably put your name in front of it to make it look like it's really a complaint when it's not. It's legally insufficient as a matter of law because it is devoid of the prerequisite elements of the offense. The elements are the facts, y'all. When I say prerequisite is just something that is required before that you can move to the next step. The facts. It's always about the facts. It's always about the facts. So let me pick up where I left off. Was this in 4? The search of Davis's home exceeded the scope of the warrant and resulted in unreasonable seizures and destruction of his property in violation of the Fourth and Fifth Amendments. For ease, what is this? I don't know. For ease of analysis, the court will address count 2 first, as it concerns events that precedes those in count 1. It then separately examines counts 3 and 4. So it seems like I'm probably going to have to read most of those just to give y'all an idea. So what the judge is going to do now, the so-called judge, is they're going to cite facts, and then they're going to cite the relevant applicable case law about those facts from here on out throughout the duration of the case. That's what they're going to do. Count 2 alleges that defendants secured the warrant to search Davis's home via an application riddled with false statements and material omissions. The Supreme Court has explained that an expectation of truthfulness attends all warrant applications. When the Fourth Amendment demands a factual showing sufficient to comprise probable cause, the obvious assumption is that there will be a truthful showing. This does not mean truthful in the sense that every fact recited in the warrant affidavit is necessarily correct. For probable cause may be found upon hearsay and upon information received from informants, as well as upon information within the affiant's own knowledge that sometimes must be garnered hastily. But surely it is to be truthful in the sense that the information put forth is believed or appropriately accepted by the affiant as true. The affiant is the one applying let me rephrase that, the affiant is the one testifying in the affidavit. That would be the police officer in this case. And then here's the case that supports what the judge just said. See this case right here? That's the case. Given this expectation, the Fourth Amendment is violated where a false statement knowingly and intentionally or with reckless disregard for the truth was included by the affiant in the warrant affidavit. If the allegedly false statement is necessary to find if the allegedly false statement is necessary to the finding of probable cause. Judicial approval of the warrant does not exonerate the affiant because the judicial officer would typically have no reason to support the falsehoods. I'm going to read that for y'all again. Judicial approval of the warrant does not exonerate the affiant, being the police officer, because the judicial officer would typically have no reason to suspect the falsehood. So they're saying just because the judge signed this warrant, this police officer is not automatically given qualified immunity. That's what they're saying. The relevant affiant here is a Ferrari. Plaintiff alleges that his warrant application contained numerous statements of his training, experience, and knowledge that were knowingly and recklessly false and misleading, and also omitted facts known to him that, if presented, would have undermined the asserted basis for seeking the warrant. That's section 60. That's where it says complaint, right? That's abbreviation for complaint, and that's paragraph 60 of the complaint. So the judge is citing it. Specifically, plaintiff asserts that a Ferrari omitted to tell the superior court judge that in the vast majority of cases in which MPD officers executed search warrants after a traffic or street stop based only on their training and experience and not actual evidence connecting the home to criminal activity, the warrant returns submitted by officers themselves prove that MPD officers do not find the items they seek. It's a good argument. The court assumes, for the purposes of the motion, although plaintiff does not specify that the underlying arrests in this sample were for drug distribution or for possession with intent to distribute rather than simple possession. Notice they're using these commercial terms, y'all. Davis states, furthermore, that in the year preceding the search of his home, MPD officers failed to find any drugs in 60% of these training and experience only searches and failed to find illegal drugs that were purportedly searching for in nearly 87% of the cases. Plaintiff insists that a Ferrari knew about the poor success rate of such warrants and misled Judge Bailey by withholding that knowledge or offering statements contrary to it. So he's saying that a Ferrari misrepresented the truth to the judge. He lied about it. He committed fraud. So in other words, he obtained this warrant via fraud or some sort of fraudulent misrepresentation. So basically, he fraudulently induced the judge into signing the warrant. That seems like what he's implying here. In moving to dismiss, a Ferrari responds that these statistics are irrelevant because an affidavit need not present all the relevant information known to the police at the time, and because only a probability of criminal conduct is required. See motion to dismiss at 9, quoting Illinois versus Gate. All right, see how they're citing these cases? This is how you got to do it. The first point is not compelling, where plaintiff's argument is that a Ferrari concealed evidence that directly undermined probable cause. Excuse me, y'all. As to the second, the court acknowledges that the test for probable cause is not reducible to precise definition or quantification. Well, yeah. At the same time, Courts have required the kind of fair probability on which reasonable and prudent people act. So while probable cause is a fluid concept encompassing the totality of the circumstances rather than rigid rules or bright lines, it turns on the assessment of probabilities in particular factual contexts. While the DC Circuit 2 decades ago sanctioned training and experience warrants for the search of suspected drug dealers' homes on the ground that there was probable cause to believe that contraband or evidence may be found there. So this is a case right here. That does not end the analysis. This is because plaintiff has alleged with some statistical support that Afroy's experience and training are to the contrary. If Davis is correct, then Afroy's statement would have been false or at least misleading. While the court agrees that there is no fixed percentage of likelihood of discovering contraband, below which a judge must deem probable cause to be lacking, it does not concur that the success rate of this type of training and experience warrant is wholly irrelevant to a probable cause determination. I'm sorry, by the way, I'm reading, y'all. So if that's bothering y'all, just pause the video and just read it at your own pace. In fact, because those success rates may undermine the key inference on which the warrant here rests, they could be crucial in this case. Okay, there's another case right there citing it. Let's see. Probable cause requires something stronger than mere uninformed and unconfirmed guesses or guess, though it is enough that the inference on which it is based was a reasonable one and confirmed with the other pieces of evidence making up the total showing of probable cause. A sworn statement of an affiant that he has cause to suspect and does believe that contraband or evidence is located on certain premises will not do. Wow. Sufficient information must be presented to the magistrate to allow the official to determine probable cause. His action cannot be a mere ratification of the bare conclusions of others, meaning he cannot make conclusory allegations of other people. A talismanic invocation of his training and experience will not, inoculate an affiant's statement. This is why you need to read cases. I learned a lot of words. I build my vocabulary up by doing this. When I read cases, I look up words that I don't know. This is how you're going to get better. You have to read cases. And whenever you see a word that you don't know, just look it up. That's all you got to do. An affiant's statement, again, against the basic scrutiny that normally attends claims of probable cause in warrant applications. Taking the complaint's allegations as true, as required at this posture, the court concludes that plaintiff has stated a claim that Afroy secured the warrant to search Davis's home with material false statements or omissions, thereby violating the Fourth Amendment. By contrast, the court will dismiss count 2 against the 25 unnamed MPD officers. Nowhere does plaintiff assert that any of them, or for that matter, any officer other than Afroy, played any role in the creation and submission of the warrant application. The complaint, in fact, proclaims that Afroy prepared and swore under oath the search warrant, okay, and that John Doe officers 1 through 25 only participated in the planning and execution of the raid of Mr. Davis's home. Absent any allegations tying these officers to Afroy's affidavit, count 2 cannot be moved forward against them. That makes sense. I agree with that. Finally, the court would be remiss not to note that plaintiff still faces an uphill climb with regard to what remains of this count. First, Davis will need to prove that deleting the purportedly false information would have vitiated probable cause. Excuse me. For there is no Fourth Amendment violation if the material that is subject to the alleged falsity or reckless disregard is set to one side. There remains sufficient content in the warrant affidavit to support a finding of probable cause. Second, he must establish that Afroy's affidavit was the product of deliberate falsehood or of reckless disregard for the truth. To satisfy this standard, plaintiff would need to demonstrate that Afroy's experience was contrary to what was averred and that he was not so trained. That may be no simple task. Okay. Reliance on the warrant. Count 1 contends that the warrant itself, once signed by the judge, was so lacking in probable cause that no reasonable officer could have relied on it, thereby rendering defendant's execution of it a violation of the Fourth Amendment. Of course, it is incumbent upon the officer executing a search warrant to ensure the search is lawfully authorized and lawfully conducted. So they mean it is reasonably authorized and it is reasonably conducted. Everything they do to you has to be reasonable. It has to be reasonable under the facts and circumstances. And I'll explain to you, well, the judge is going to explain to y'all some of what they mean by that. At the same time, courts have recognized that it is inevitable that law enforcement officials will, in some cases, reasonably but mistakenly conclude that probable cause is present, and thus, in such cases, those officials, like other officials who act in ways they reasonably believe to be lawful, should not be held personally liable. This is where I was telling y'all that they're allowed to violate the Fourth Amendment and still get granted qualified immunity if they act reasonable. For this reason, the protection of qualified immunity is available if a reasonable officer could have believed that his or her actions were lawful in light of clearly established law and the information the officers possessed. The court considers Afroy separately from the other officers. Here, Afroy directly prepared the warrant application and accompanying affidavit. If, as plaintiff maintains, his affidavit included knowingly false statements or material omissions, Afroy cannot hide behind the judge's stamp of approval. Because petitioner himself prepared the invalid warrant, he may not argue that he reasonably relied on the magistrate's assurance that the warrant contained an adequate description of the things to be seized and was therefore valid. On these facts, consequently, the court must conclude that it was not objectively reasonable for Afroy to rely on the warrant in executing the search because of his knowledge of those misrepresentations or omissions. As such, he is not entitled to qualified immunity, and count 1 survived against him. So they denied him qualified immunity. So what they're saying is, even though this judge signed the warrant, or this magistrate judge signed the warrant did not contain probable cause. And because the warrant did not contain probable cause, the officer or the affiant or Afroy who procreated that warrant should not be granted qualified immunity because it was objectively unreasonable for him to rely on the facts. Let me see, where is that? Anyway, it's right there. But anyway, y'all just keep reading over this stuff. You have to keep reading and keep reading and keep reading and keep reading. It will eventually click. Give me 1 second, y'all. I'll be right back. Okay, now they're talking about the 25 police officers. If I'm not mistaken, this is where they're going to get into the reasonableness, or in other words, the manner in which a search of your home is to be conducted. The 25 unnamed MPD officers are in a different position altogether. Unlike a Ferrari, none of them participated in the preparation and submission of the warrant application. They thus had no ex ante reason to distrust its contents. The question, accordingly, is whether they could reasonably rely on the warrant once signed by the judge. Notice they keep using that word reasonable, y'all. Reasonably. Reasonably, reasonable. I told y'all they throw that word around everywhere, man. Everywhere. Typically, it is the magistrate's responsibility to determine whether the officer's allegations establish probable cause, and, if so, to issue a warrant comporting in form with the requirements of the Fourth Amendment. In the ordinary case, an officer cannot be expected to question the magistrate's probable cause determination or his judgment that the form of the warrant is technically sufficient. Let's see. Only where the warrant application is so lacking in indicia means an indication of probable cause. This term right here means an indication. I don't know why they just didn't say that. An indication of probable cause as to render the official belief in the existence unreasonable will the shield of immunity be lost. So they're saying is only the police officer will only lose immunity if it's just obvious just by them looking at the warrant, the so-called warrant, by looking at the facts in it. If it's so obvious that it's just lacking in probable cause, that's the only time that they will be denied immunity, if I'm not mistaken. If a reasonable officer could have believed that the warrant application was valid, therefore, he is entitled to qualified immunity for executing the warrant, even if a court later deems it invalid. Officer entitled to qualified immunity where a warrant was not facially invalid. Facially invalid. That means you have to, it's prima facie. You can just look at it and just, this ain't no warrant. This ain't no warrant. That's what they're talking about. Here, though the warrant authorizing the search of Davis's home was duly signed by a superior court judge, plaintiff nonetheless maintains that the application lacked probable cause on its face. The court does not agree. Okay. So he said he doesn't agree. Let me see. This must be a response op-ed number 2. The court does not agree. Okay, let's see. The D.C. Circuit has been clear that observations of illegal activity occurring away from the suspect's residence can support a finding of probable cause to issue a search warrant for the residence if there is a reasonable basis. Now, notice they just keep throwing that word around, y'all. They just keep throwing it around. Keep throwing it around. If there's a reasonable basis to infer from the nature of the illegal activity observed that relevant evidence will be found in the residence. In his affidavit supporting the warrant application, Afrori averred that he is responsible for investigating narcotics offenses, in which capacity he has become familiar with the methods and techniques associated with the distribution of narcotics. Let's see. Afrori explained that at the time of Williams' arrest, he was found to be carrying 4.1 grams of heroin, and based on officers' experience and training, the amount and packaging of the drugs that the defendant was in possession of, along with the amount of currency, $235, is more consistent with the possession with the intent to distribute rather than mere possession. No, it's not. No, that's not. He then stated that, but I guess that's subjective. So somebody would say yes and somebody would say no. So that's a subjective right there. He then stated that based on his training, experience, and extensive participation in narcotics and drug-related investigations. So they got a footnote right here. Let's go down here. He knows that individuals who deal in illegal and controlled substances maintain books, records, receipts, large quantities of currency, financial instruments, jewelry, and other items of value, typically proceeds of illegal controlled substance transactions, telephone number, books, or papers which reflect names, addresses, and other telephone numbers for their associates in their legal organization. Photos of themselves, their associates, their property, and illegal contraband, fictitious names, false identification, cashier's checks, and cellular phones relating to cash transactions, usually secreted in their residence or the residence of friends, family members, or associates, or in the places of operations of the drug distribution activity, such as a stash or safe house. This is telling you what not to do if you're going to sell drugs. This is telling you what not to do if you're going to sell drugs. These statements seem to be precisely the sort contemplated by Thomas and his progeny. For example, in the United States versus Washington, 2014, the court held that where the affidavit points to general practices of drug traffickers and the affiant's officer's observations in his extensive expertise in drug enforcement, that drug traffickers rarely keep on their person their entire supply of drugs and instead commonly retain much or most of their drug supply in the home or stash house. The officer executing the warrant authorizing search of drug trafficker's home could certainly harbor Leon's objectively reasonable belief that contraband or evidence would be found within. Okay. Common experience suggests that drug dealers must mix and measure the merchandise, protect it from the competitors, and conceal evidence of their trade, such as drugs, drug paraphernalia, weapons, written records, and cash in secure locations. For the vast majority of drug dealers, the most convenient location to secure items is the home. After all, drug dealers do not tend to work out of the office building, and no training is required to reach this common sense conclusion. Let's see. There's a case right here. Affidavit to search one of the defendant's two residences was sufficient to establish probable cause, where it relied on testimony that, in the affiant's expertise, drug dealers frequently kept their business records, narcotics proceeds from sales, and firearms in their homes. Let's see. This principle is well established in our circuit, as well as in many others. Blah, blah, blah. Let's see. Give me a second, y'all. I'm going to pause and see what's else that is necessary for me to read, because I don't want to bore y'all. All right, y'all. I scroll down a little bit more. I'm going to wrap up the first cause of action, count 1, against the 25 defendants, police officers, and then we'll keep going from there. As to the 25 unnamed MPD officers who executed the search warrant, then the court cannot conclude that their belief in the validity of the warrant was objectively unreasonable. And this is true regardless of the role they played. What's reasonable for a particular officer depends on his role in the search. Although those who lead the team must read the warrant and assure themselves of its sufficiency, line officers do not have to actually read or even see the warrant. They may accept the word of their supervisors that they have a warrant and that it is valid, so long as they make inquiry as to the nature and scope of the warrant. Their reliance on the leader's representations about it is reasonable. As the unnamed officers are entitled to qualified immunity for their reliance on a facially valid search warrant, the court will dismiss count 1 as to them. I'm going to scroll down and we're going to go to another section. Be right back. All right, now this section is very important. This is going to talk about the manner in which a search warrant is executed in. It has to be reasonable. And if it's not reasonable, then they'll lose immunity. In his final count, plaintiff alleges that all the officers, including Afrori, violated the Fourth Amendment by exceeding the scope of the warrant when they ransacked his residence and unlawfully seized his computer. In response to the computer allegations, the district points out that the warrant expressly included computers in the listing of property being concluded. See warrant application, blah, 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 and that the search warrant was valid. As the court has already determined that it was objectively reasonable for the unarmed officers to rely on the warrant in executing the search, blah, 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 they could permissibly seize the computer. As to Afrori, if it was unreasonable for him to rely on the warrant in executing the search, it was unreasonable for him to rely on it in seizing items. Excuse me, y'all. The computer claim consequently survives against him. Davis's allegations that defendants exceeded the scope of the warrant when they recklessly destroyed his property, specifically when they damaged his door, shredded plaintiff's mattress and armchair, and split boxes of food open, presents a closer question. While the officers may have reasonably relied on the warrant, that alone does not absolve them from any potential liability from the manner of its execution. The conduct of police officers in executing a search warrant is always subject to judicial review as to its reasonableness, and the officers may be held liable under Section 42, 1983, for executing a warrant in an unreasonable manner. Though courts do recognize that officers executing search warrants on occasion must damage property in order to perform their duty, whether a search is unreasonable must be determined by the particular facts of the case, including the scope of the search, meaning the limit of the search, authorized by the warrant. Destruction of property that is not reasonably necessary to effectively execute a search warrant may violate the Fourth Amendment. The warrant here authorized the officers to search a variety of materials, including items that are easily hidden, such as drugs, as well as records of and proceeds from illegal drug transactions. Defendants assert that an officer could reasonably believe that these items were hidden away in a mattress or armchair, while plaintiff rejoins that the search of his armchair, mattress, and food was unnecessary. Taking the complaint at its word, as the court must, Davis has the stronger position. For even if the search for these small secreted items necessitated some damage to the property, the court cannot conclude that the officers acted reasonably when they shredded the armchair and mattress and split Mr. Davis's boxes of frozen food and emptied them, absent any indication that contraband or evidence would be found in them. Such extreme and destructive tactics are hardly the norm for searches of drug traffickers' homes. Agents found a razor blade with cocaine residue hidden between the mattress and box spring of the bed. Where a broadly worded warrant authorized defendants to search plaintiff's residence for concealed drugs, the defendant officers had every reason, indeed every right, to search the closets, beneath sofas, and behind the picture frames for concealed drugs. While a lawful search of fixed premises generally extends to the entire area in which the object of the search may be found and is not limited by the possibility that separate acts of entry or opening may be required to complete the search, the court does not believe that the opening of an item not traditionally open which also renders that the item completely unusable, in the furniture, shares the same presumption of reasonableness. Although neither party raises the issue here, it may be helpful as summary judgment also to consider the question of proportionality, i.e., whether the scope of the search depends at all on the seriousness of the underlying crime. In any event, plaintiff has stated a claim that MPD searched unreasonably exceed officers' search unreasonably exceeded the scope of the warrant in contravention to the Fourth Amendment. Count 4 thus survives. So I just wanted to read that to y'all so y'all can get an idea. This is how you litigate a case. You make your argument by asserting facts, and you cite case law in support of those facts, okay? And then you make reasonable conclusions based on what the case law says about those facts. That's what the opposing counsel is going to do, okay? And when you do that, since y'all are arguing over it, and since this is a question of law, it's going to go to the judge. The judge is going to decide it. That's how it works. Questions of fact are answered by the jury when there's a jury present, and questions of law are answered by the judge, so-called judge, that is. So this stuff is not hard, y'all. It is not hard. You can do this. As you can see, in this particular case, at this particular stage of the litigation, this officer who had an arrest warrant signed by a judge was denied qualified immunity because of false misrepresentations to the judge, and because the plaintiff is arguing that the arrest warrant is not supported by probable cause. So, in other words, what I'm trying to get y'all to understand is, even if a judge signs off on the warrant, if the warrant is not supported by probable cause, meaning facts, it's always the facts, then it is not a warrant. It is invalid. It's not a warrant. I don't care if 1,000 judges sign off on it. A warrant needs it has to have ingredients. It has to be testimony coming from someone who has personal knowledge and competent to testify. And the contents on what the affiant is testifying about has to be facts, and these facts on their face, as soon as you look at them and read them, you have to be able to reasonably conclude that a crime was committed. When you do that, you're gonna give it to the so-called judge or whatever, and the judge is gonna say, "Okay, I agree with that," and he's gonna sign off on the warrant, whether it be to arrest you or to to come and see some of your property or something like that. That's how it works, y'all. That is exactly how it works. So I hope this video helped y'all. I apologize for my stuttering. But anyway, hope everybody enjoys their day. That'll be the end of this video. The Supreme Litigant is out. Peace.